This is Tom Horn. I will tell you a few words about myself. I have been a litigation lawyer for 45 years. I have specialized in construction law since 1978, when the Arizona State Bar published a book I wrote on Arizona construction law. In that book, I discuss every case ever decided in the state of Arizona involving construction law. I wrote the summaries of the cases in a way that would be understandable to contractors. You can obtain a copy from the State Bar of Arizona. I do not receive royalties, so this is not a commercial message. The first topic is pay me or lose your property, liens. If you are unpaid and successfully foreclose on a lien, the owner's property will be sold by the sheriff to generate the funds to pay you. This is a powerful tool. Here's an example of how powerful it is. Assume you're a subcontractor. The owner pays the general contractor for your work, but the contractor becomes insolvent and does not pay you. If you follow what you learned today and properly perfect a lien and foreclose on it, the owner will have to pay you a second time for the same work that he had already paid the general contractor for. The Arizona Supreme Court explained this rule in a 1950 case as follows. Experience has shown that mechanics and materialmen who furnish labor and materials for the construction of buildings are often defrauded by insolvent owners and dishonest contractors. So, when a person enters into a contract for the erection of a building on his land, this law enters into and becomes a part of the contract. He knows that the contractor is his agent and clothed with the statutory authority to bind his property for the reasonable value of such labor and of such material as may be furnished for the completion thereof. If the owner wishes to be protected, he must trouble himself to inquire what has been the fate of those whose labor and materials have constructed the improvement before he pays the stipulated price. I'm going to quote one more case for you. Adams Tree Service versus Transamerica Title, decided in 1973, in which the court said, the Arizona lien statutes are confusing and difficult to understand. However, I'm going to make it simple for you so that you can protect your rights. So how do you get the benefits of this powerful statute that, as the Arizona Supreme Court says, forces owners to trouble themselves to make sure that you get paid? First, you must file a preliminary 20-day notice under ARS Section 33-992.01. You do this on all your jobs, not just for the ones for which you have a payment problem. It simply alerts the owner that you exist and expect to be paid. The form of the preliminary 20-day notice is set forth in the statute, and it requires a statement that this is not a reflection on the integrity of any contractor or subcontractor. This is called a 20-day notice because it covers all work that you do from the date 20 days prior to your filing the notice into the future. If you are late in filing your preliminary 20-day notice, then any work you have done more than 20 days before the filing will be work for which you are not entitled to a lien. Obviously, you can still sue anyone you had a contract with, but you will lose the benefits of the lien that we're talking about this morning. Service is made by first-class mail with a certificate of mailing or registered or certified mail. You must serve the owner, general contractor, and construction lender. There are services that will do preliminary 20-day notices for you. Now, what happens if you don't get paid? You file your lien with the county recorder, and within a reasonable time, serve another copy on the owner of the structure. The lien is now a cloud on the owner's title. This is an incentive for him to pay you. However, the lien will evaporate within 6 months unless you file a lawsuit to foreclose on the lien within that 6-month period. Within 5 days of filing the lawsuit, you must file a lis pendens with the county recorder. A lis pendens is a notice in the property records that you sued to foreclose your lien. If you miss that 5-day deadline, the lien and the lien foreclosure action are extinguished. Who can file a lien? Contractors, subcontractors, and those having control of the project, in whole or in part, are statutory agents of the owner for purposes of creating a lien. That means if you provide work or materials at the request of a statutory agent, you are entitled to a lien. An agent normally is someone you control that can create liability for you. If you send your secretary to the stationery store to buy stationery, you are responsible to pay the bill, even if you never spoke to the store. Statutory agency would refer to someone who would not normally be considered an agent, such as a contractor or subcontractor doing work for an owner. They create liability for the owner just as a real agent would, even though they are not a real agent, because the statute says so. The tricky part is material suppliers. If they deal with a contractor or subcontractor, they are dealing with a statutory agent and they have a right to a lien. But the material suppliers themselves are not statutory agents, so a second-tier material supplier who supplies to another material supplier is not entitled to a lien because he did not deal with a statutory agent. What is the deadline for filing your lien? It is 120 days after completion of the structure, or 60 days if the owner records a notice of completion. Completion is defined as 30 days after final inspection and acceptance by the governmental body which issued the building permit, or abandonment. I once taught a seminar in which I said what I just said now, and one of the people in the audience said, "Not from completion of the project, but from the last day I did my work." I said, "No, from completion of the project." He became angry. He had gone to see a lawyer, and the lawyer said, "When did you last do your work?" The lawyer told him he was too late. Actually, he was not too late, because he was within the period after completion of the project, which was later than when he completed his work. The lawyer had asked him the wrong question. He had lost a lot of money as a result. He was upset. I did not know what to say. But I know that none of you will be victimized in that way because you now know the rule. Suppose you have a valid lien, you sue to foreclose it. There is an order of foreclosure on the property, a sheriff's sale, but the proceeds are not enough to cover both you and the mortgage holder. Who gets priority? If the mortgage was recorded before the first person who performed work started, then the mortgage holder gets priority. Otherwise, you get priority. Note that I did not say when you first do your work. The rule is when the first person starts work on the project, regardless of who it is. As between lien claimants, if there is not enough money to go around, you will share pro rata, regardless of when work is performed or claim was made. Suppose the general contractor's work is not with the owner of the property, but with the lessee, as in a shopping center. If the lease requires the lease to make the improvements, then you still have a lien against the owner. But if the lease simply permits the improvements, but does not require them, then you have no lien against the property. Your only lien is against the leasehold interest. The leasehold interest may have value if the lease rates are below market and the lease is for a long term. After a foreclosure sale, how much of the proceeds will be paid to you for your lien? If you have a contract with the owner, it will be the unpaid amount of the contract. If you don't have such a contract, such as a subcontractor or material supplier, then you can collect the reasonable value of your materials or labor. Reasonable value is reasonable value in the market, regardless of the value to the owner specifically. The amount of your contract, even though it is not with the owner, is prima facie evidence of the reasonable value of the services you rendered. Our second topic this morning is the following. Oops, I lost my lien rights. What are the other actions against the owner where there are no liens? First, suppose you have a contract with the owner, as with general contractors or others having a contract directly with the owner. You can sue on your contract. I have had general contractors upset that they missed a deadline on a lien, and I told them, "Don't worry, you have a contract. You can sue on the contract." Second, even if you're not a general contractor, you have action against an owner if you have a contract with an actual agent of the owner, as opposed to the statutory agent I spoke about earlier. An actual agent is someone under the direct control of the owner. Arizona cases discuss this possibility, but it would be rare in the construction context because most people the owner deals with would be independent contractors rather than agents. Third, and perhaps most interesting, is the theory of restitution. This is under the Restatement of Restitution, Section 40. It provides that restitution is in order for a person who accepts services from another with reason to believe the other expects to be paid either by that person or by a third party. This is a good theory to use if there is a technical defect in your claim of lien, such as a missed deadline. The drawback is an example with which I started this webinar. That is where the owner pays the general contractor. The general contractor becomes insolvent. The subcontractor forces the owner through a lien to pay for the same work a second time. The theory of restitution is based on what is called unjust enrichment. Since the owner paid once, there is no unjust enrichment. So the benefit of restitution is that you're entitled to it even if you don't meet the technical requirements of a lien, but the detriment is you can't make the owner pay a second time if he's already paid once, which you could do if you had a valid lien. Our third topic this morning is getting paid for extra work. Of course, it is a good practice when you're asked to do extra work to get it in writing with a signature. But suppose you're asked orally by the owner to do extra work and you neglect to get it in writing. Suppose further that there is a contract that says there will be no payments for extra work unless pursuant to a written agreement signed by the owner. Are you out of luck? No. Even if an owner has that provision in his contract, if he orally asks you to do extra work, the courts have held that he is waiving that provision. You can still sue for payment for the extra work, even if you didn't get it in writing, and even if there is a provision in the written contract prohibiting payment for extra work not in writing. Of course, you still have an evidentiary problem. It is your word against his. That's why it's always better to get it in writing. Even when you do get it in writing, make sure the person signing has authorization. In some cases, owners have gotten out of paying for extra work by arguing that the person who authorized extra work, whether orally or in writing, lacked authorization. Sometimes you can answer this argument by saying that even though the person did not have actual authorization, he had apparent authorization. That would be a person who was in a position that a reasonable person would believe did have authorization. Another defense that has been raised to paying for extra work is that the statute of limitations ran, if measured from the period that the extra work was completed. However, the courts have held that the statute of limitation does not begin to run until the entire contract or subcontract is completed, rather than after each item of extra work is completed. I hope this morning's webinar has been useful to you.